America woke up today to something nobody thought would come this fast, this sharp, or this explosive. Forget the debates. Forget the predictions. Forget the polls. Because overnight, the Supreme Court just dropped an emergency order so powerful, so sweeping, and so unexpected that it sent shockwaves through every corner of the country. Gun owners are stunned. State governments are scrambling. Federal agencies are in absolute meltdown mode. And the media, they can't decide whether to panic, spin it, or pretend it isn't happening. But the truth is out there, and it's hitting harder than anyone expected. Major gun rules across the country have just been overturned immediately, decisively, and without warning. This wasn't a quiet ruling. This wasn't a slow-moving case. This wasn't some legal technicality that lawyers debate behind the scenes. This was an emergency intervention from the highest court in the United States delivered with one message. The Second Amendment means what it says, and any rule that crosses that boundary is about to feel the hammer of the Constitution. And tonight, we're breaking it all down. Exactly what happened, how this emergency order detonated like a legal grenade, what gun restrictions were thrown out instantly, which states are already ignoring federal guidance, and why this ruling may reshape every major firearm case for the next 20 years. Because this wasn't just an order, this was a declaration. The energy across the country shifted within minutes of the ruling being released, not hours, minutes. When the Supreme Court issues a normal decision, it comes after months of hearings, thousands of pages of filings, and carefully crafted opinions. But this time, the court bypassed the usual process, choosing instead to invoke emergency authority and fast-track a constitutional correction that officials have been avoiding for years. The court made it painfully clear several states and federal agencies have been enforcing gun policies that cross the boundaries set by the Constitution, and the justices were no longer willing to let those rules stay in place. While litigation dragged on for years, legal experts were stunned, not because the court intervened, but because of how aggressively it intervened. The order was sharp, blunt, and unambiguous. It didn't pause the rules. It didn't limit them. It overturned them, declaring that the regulations in question created unconstitutional burdens on lawful gun owners, violated the historical standard established under Bruin, and imposed restrictions the government could not justify with any historical tradition. What rules were overturned? The ruling targeted several high-profile regulations that had been the source of major lawsuits for months. These rules varied from state-level restrictions to federal enforcement policies that were implemented through agency power rather than congressional approval. The emergency order effectively froze them, dismissed them, and told authorities they had no legal foundation to stand on. Overnight, thousands of gun owners who had been living under the threat of penalties, compliance deadlines, and registration requirements were suddenly freed from those legal pressures. Immediately after the ruling went public, attorneys general across multiple states launched emergency meetings. Some states accepted the ruling quietly. Others fired back, declaring they would continue enforcing their regulations anyway. And yes, before the dust even settled, governors and officials began issuing statements claiming that the Supreme Court had gone too far, that this was reckless judicial activism, and that states had the right to create their own firearm policies, even if those policies contradicted the Constitution. But here's the truth. For the Supreme Court to issue an emergency order of this magnitude, the justices had to conclude that the gun rules in question posed not just a constitutional problem, but an urgent one, something so serious that waiting for the full legal process would cause irreparable harm to millions of Americans. That phrase, irreparable harm, is not used lightly. The court only invokes it when fundamental rights are at risk. Gun rights organizations erupted with applause, calling this the most significant emergency order in modern Second Amendment history. Social media exploded instantly. Hashtags trending, influencers reacting, and gun channels across YouTube going live with instant analysis. But on the other side, activist groups unleashed immediate outrage, declaring the decision an attack on common sense protections and announcing nationwide protests. And while the public reaction was loud and chaotic, the internal fallout inside government agencies was even more intense. Federal enforcement divisions were told to halt active investigations tied to the now overturned gun rules. States with registration mandates saw their systems instantly thrown into legal limbo. Judges in lower courts began issuing temporary clarifications because ongoing cases were suddenly overturned mid-process. Lawyers representing defendants in firearm cases filed emergency motions within hours demanding dismissals. And the political world, it erupted like a volcano. Members of Congress rushed to the cameras with critics accusing the court of sabotaging safety, while supporters praised the ruling as a historic defense of constitutional rights. Presidential candidates issued statements within an hour of the order's release, turning the ruling into a national flashpoint overnight. And you don't have to guess which states applauded the ruling and which states vowed to fight it. You already know exactly how the map breaks down, but here's where the story gets even bigger. This emergency order wasn't issued in isolation. It was tied to a broader pattern of cases that have been working their way up through the courts since the Bruen decision, each challenging different types of firearm regulations. For months, lower courts have been divided, some following the historical standards set by Bruen and others attempting to reinterpret or resist it. The Supreme Court's emergency order is being read as a warning shot, a message, a signal that the highest court is preparing to step and farm more aggressively to enforce compliance with the Second Amendment. Legal scholars are calling it the beginning of a massive shift, a prelude, or even the first domino. If this order is the opening move, the long-term implications could be enormous. Assault weapon bans, magazine limits, permitting schemes, registration requirements, agency-made rules, state-level restrictions built on vague safety claims. All of those laws and many more could now be vulnerable in ways they weren't just 24 hours ago. And the timing of the order is what truly has the political world on edge. It wasn't issued at the end of the term. It didn't come after months of deliberation. It was issued in the middle of growing conflict between the federal government, state governments, and millions of gun owners, at a moment when old legal doctrines are collapsing and new ones are rising. But let's break down why this matters so much. For decades, gun regulations were evaluated based on intermediate scrutiny, a legal test that allowed governments to defend restrictions by claiming they were reasonable or beneficial. That era is dead. Bruen replaced it with one standard and one standard only. If the government cannot show a historical tradition for a firearm restriction, it is unconstitutional, period. No balancing tests, no subjective opinions, no policy justifications. The Constitution demands history, not hypotheticals. This emergency order reinforced that standard with absolute authority. The court didn't reject the challenged rules because they were controversial. It rejected them because the government failed, once again, to provide evidence that such restrictions existed at any point in American history. And when the government cannot produce that evidence, the court no longer hesitates. Multiple justices underscore the urgency of protecting constitutional rights without delay. They emphasize that Americans cannot be forced to comply with potentially unconstitutional rules while waiting years for litigation to resolve. In their view, if the government oversteps its authority, the burden cannot fall on the citizen. That philosophy shaped this ruling, and it may shape many more to come. Across social media, gun owners began posting reactions, many celebrating newfound clarity after months of uncertainty. Others joked about throwing away compliance papers. Some asked whether they still needed to register, store, or modify firearms according to the overturned rules. Lawyers are now advising Americans to watch for state-level announcements because despite the Supreme Court's order, some states may attempt to reinterpret or resist the ruling. Legal battles will continue, but the Supreme Court's message was clear: the Constitution is not optional. And that brings us to the elephant in the room, the political implications. Tonight's ruling instantly became a defining moment in the national conversation about gun rights. The timing, right in the middle of election season, means this decision is about to dominate rallies, ads, speeches, debates, and proposals. Candidates will use it to energize their supporters. Critics will use it to warn of chaos, and voters, they will decide which vision of America's future they believe in. But beyond politics, beyond the media hysteria, beyond the online commentary, this ruling touched something deeper, a foundational question about America's identity. What does it mean to uphold the Constitution? Who decides where the limits are set? And how far can governments go before the people push back? Tonight's emergency order is not the end of the story. It is the opening chapter of a much larger legal battle, one that is already shaping the future of firearm rights in the United States. And in many ways, this is exactly the kind of moment the founders wanted the courts to act on. A moment when government authority expands beyond its constitutional boundaries and the Supreme Court steps in to restore balance. In the coming days, you will hear endless reactions, some accurate, some exaggerated, some politically motivated. But here's what we know for certain. The Supreme Court just made one thing unmistakably clear. The rights of lawful gun owners are not optional. They are not negotiable. They are not subject to shifting political winds or agency interpretations. They are constitutional rights protected, guaranteed, and enforceable.